Well, hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today will be the day I earn that subscription. For today's story, we are doing the end of the Supreme Court term. Yes, my friends, it is the end of June, the last day of June, and as is tradition for the Supreme Court, the last day in which opinions are released. They've been pushing it a little bit in the last couple of years, where they've been issuing them in early July, like July 1st or 2nd. And everyone gets a little bit weird. What's going on? Why is it July and we're still releasing opinions? What's happening? But fortunately, we're back to the old ways. It's the last day of June. So it's the last day of the Supreme Court term. The Supreme Court's term is from the first Monday in October until the last day of June. And being on the last day of June is the day in which we're going to issue opinions. We've got two opinions of notes. We've got one dealing with Justice. Well, let's try that again. We got one dealing with Breyer. No, try again. One dealing with Biden. That's the one I was looking for. That's going to be of interest. And also one that's called West Virginia versus EPA, which, depending on how it goes, could make me very, very happy. But we'll find out how happy I'm going to be or not. Maybe I'll just be really frustrated, as I've been so many times before. We don't know. And then perhaps as time allows, we will cover more stuff dealing with other things. We might go into yesterday. And we also might go into justice, might go into justice. Yes, those are the ones I was looking for. Chief Justice Roberts' opinion in the abortion case, because I thought it might be interesting. Also, as of 12 noon Eastern, Justice Breyer is no more. He is officially retired. And I suppose, Judge at the moment, Judge Jackson will be sworn in today. Will be sworn in at the 104th Associate Justice at noon at the Supreme Court. So at the moment that Justice Breyer is no longer Justice Breyer, Judge Jackson becomes Justice Jackson, and we will see how it all goes from there. And good morning to everyone. So all the rest of it. I look sleepy? No, feeling pretty good, man. Yeah. So we will see what happens today. And we can go through Robert's opinion. It would be interesting to see what his analysis has to be. I continue to think that the majority's opinion when it comes to the pre-quickening stuff is a little bit questionable. And I think that its logic is a little bit strange. It doesn't seem that the history really criminalized abortion pre-quickening. Any sort of judicial decisions or treatises to the apparent contrary. It's not even clear that they are in contrary, and even if they are, they're a little far and few between. This is one of the aspects of the dissent of the abortion case that had it right. The dissent chastised the majority for looking at these old obscure decisions when they themselves eschewed those same kinds of authorities when discussing the gun case. So you can't use it one place and not the other if we're going to be intellectually consistent. So we'll see with that. Please don't think I'm a creeper, but your eyes are gorgeous. Thank you. That's very validating. I appreciate it. Thank you for covering these better than SCOTUS blog. Well, I appreciate that too. Hope you're good from sunny Scotland. I've heard tell that it's not that sunny, but maybe today is an exception to the rule. Yeah. This is way better than SCOTUS blog for us normies. Aw, you guys just know the sweetest things to say. So I thought maybe we could get into Chief Justice Roberts' opinion, and maybe we could even read the dissents, because I think the dissent might have some legitimate points of criticism when it comes to the majority's decision on the abortion thing. I think Roe is garbage. I think Casey is garbage. I don't think they make any sense. But, as long as we're going to replace the stupid, we should try to get it right. So any sort of criticism can be fun. So we'll see how it goes. And then And then in honor of certain people who are requiring of hope, in honor of certain people who are requiring of hope, I would like to sing this song. I believe I can fly. I believe I can touch the sky. Think about it every night and day. Spread my wings and fly away. I believe I can soar. See me running through that open door. I believe I can fly. I believe I can fly. I believe I can fly. Well, keep seeing yourself running through that open door, my friend. Maybe your visualization exercises will come to pass. Drew says, thanks for coming this, sending best wishes from Scotland too. Scotland is my ancestral home on my mother's side. I am Scottish through and through, having done my genetic and familial research. So when the Scotland loves me, I feel a little bit love in here. Thank you. I look rested. I feel rested. Thank you. So I am a true Scotsman. Maybe. I got the joke. I like jokes. Truth. Who was the surprising Lawtuber you liked more than you thought you would? And conversely, who do you think you'd like connect with more than you did? I connected with them all pretty well. I'm trying to think if any of them really surprised me in any way. They're all pretty true to themselves and pretty true to their personas online. Their personas are maybe a little bit richer in person, but they are kind of who they are. I was surprised how tall Legal Bites is. That surprised me. And then I've heard tell that people are surprised how tall I am. This appears to be a bit of a thing. I've noticed in some of the Twitter comments, and people seem to be surprised that I'm as tall as I am. Apparently, there was a bet with Andrew from Legal Mindset, and they were betting on how tall I am. I think Andrew lost. I'm not sure what he lost, but apparently there was some sort of bet regarding my height, and apparently the bet was I was shorter than I am. So, yeah. Are you hoping they overturn Chevron? Yes, that'd be great. That'd be great. We're about to find out right now because they're releasing the opinion right now. Is by the chief. Kagan dissents destroyed by Breyer and Sotomayor. Well, let's see. Because my camera angle? Okay. Well, whatever. That was a total dodge of an answer. It was just honest. I mean, I suppose if I had to be surprised by anyone in terms of how well connected it would just be Nate the lawyer. But we had already spent so much time together in terms of it. Like a good third or 40% of my channel is like development is in some sense driven by my relationship with Nate the lawyer, because he's sort of the person I collabed with the most after learning French. Anyways, that is so maybe how well and how easily we got along maybe was slightly surprising, but I mean, or how familial our relationship felt in some ways. Maybe it's slightly surprising. Let's see what we got on EPA. 2015, the Environmental Protection Agency promulgated the Clean Power Plant Rule. This is the exact same damn thing that Chevron was based off in the first place. This is Chevron. which addressed carbon dioxide emissions from existing coal and natural gas fired power plants. For this authority, the agency cited Section 111 of the Clean Air Act, which, although known as the New Source Performance Standard Program, authorizes regulation of certain pollutants from existing sources under the law. This is Chevron. No wonder this is Chevron again. Prior to the Clean Power Plant, EPA had used the section only a handful of times since its enactment. Under that provision, although states set the actual enforcement rules governing existing sources such as power plants, EPA determines the emissions limit with which they will have to comply. The agency derives this limit by determining the best system of emission reduction that has been adequately demonstrated, or the BSER, for the kind of existing source at issue. The limit then reflects the amount of pollution reduction achievable through the application of that system. In the Clean Power Plan, the EPA determined the BSER for existing coal and natural gas plants included three types of measures, which the agency called building blocks. The first building block was the heat rate improvements at coal-fired plants, especially practices such plants could undertake to burn coal more cleanly. This sort of source-specific efficiency improving measure was similar to those in kind the EPA previously identified as the BSER in other Section 111 rules. Building blocks 2 and 3 were quite different, as both involved what the EPA calls generation shifting at the grid level. That is, a shift in electricity production from higher emitting to lower emitting productions. Building block 2 was a shift in generation from existing coal-fired power plants, which would make less power, to gas-fired power plants, which would make more. This would reduce carbon dioxide emissions because natural gas plants produce less carbon dioxide per unit than coal. Building block 3 worked like building block 2. This is a lot of technical detail. Building block 3 worked like building block 2, except this shift was both coal and gas plants to renewables, mostly wind and solar. The agency explained that to implement the shift in generation to cleaner sources, an operator could reduce the regulated plant's own production of electricity, build or invest in new or existing power plants, wind farm, or solar installation, and purchase emission allowances or credits as part of a cap and trade regime. Taking these steps would implement a sector-wide shift in electricity production from coal to natural gas. Having decided that BSER was one that would reduce carbon pollution, mostly by moving production to cleaner sources, do we need this much technical detail for the decision? Okay, pressing on. Having decided that the BSER was one that would reduce carbon pollution mostly by moving production to cleaner sources, EPA then set about determining the degree of emission limitation achievable through the application of the system. The agency recognized that in translating the BSER into an operational emissions limit, it could choose whether to require anything, from a little generation shifting to a great deal. It then settled on what it regarded as a reasonable amount of shift, which is based on modeling how much more electricity both natural gas and renewable sources could supply without causing undue increase or reducing overall power supply. The agency ultimately projected, for instance, that it would be feasible to have coal provide 27% of national electricity generation by 2030, down from 38% in 2014. From these projection changes, the EPA determined the applicable emissions performance rates, which were so strict that no existing coal plant would have been able to achieve them without engaging in one of the three means of generation shifting. The government proposed the rule would impose billions of dollars in compliance costs, raise electricity prices, require retirement of dozens of coal plants, and eliminate tens of thousands of jobs. The court stayed the Clean Power Plan in 2016, preventing the rule from taking effect. It was later repealed after a change of presidential administration. Specifically, in 2019, the EPA found the Clean Power Plan had exceeded the agency's statutory authority under Section 111, which he interpreted to limit the BSER to those systems that can be put into operation at a building, structure, facility, or installation. EPA explained that the Clean Power Plan, rather than setting the standard based on the application of equipment and practices at the level of individual facility, had instead based it on a shift in the energy generation mix at the grid level. The agency determined that the interpretive question raised by the Clean Power Plan fell under the major questions doctrine. Okay? Under that doctrine, it determined a clear statement is necessary for the court to conclude that Congress intended to delegate authority of this breadth to fundamental sector of the economy. It found none. The agency replaced the Clean Power Plan by promulgating a different regulation known as the Affordable Clean Energy Rule. In that rule, the EPA determined the BSER would be akin to building block 1 of the Clean Power Plan, a combination of equipment upgrades and operational practices that would improve facilities' heat rates. Well, all I'm reading so far is that the agency is making shit up, which they do all the time, and are changing their minds on the various regulations about what it means as it changes over administrations and stuff. This is nothing new. So sounds like just stock normal stuff in terms of what the agencies do. So let's see what happens. A number of states and private parties filed petitions for review in the D.C. Circuit, challenging the EPA's repeal of the Clean Power Plan and its enactment of the replacement rule. Under the current law, they can do that. So, okay. The Court of Appeals consolidated the case and held the EPA's repeal of the Clean Power Plan rested critically on a mistaken reading of the Clean Air Act. Namely, generation shifting cannot be a system of emission reduction under Section 111. The court vacated the agency's repeal of the Clean Power Plan and remanded the agency for further consideration. It also vacated and remanded the ACE rule for the same reason. The court's decision was followed by another change. In presidential administration, the EPA moved the court to partially stay the mandate as to the Clean Power Plan while the agency considered whether to promulgate a new Section 111 rule. No party opposed the motion, and the Court of Appeals agreed to stay its vacatur of the Clean Power Plan. This just sounds like the normal mess that administration law can be. Okay. Held. This case remains judiciable, notwithstanding the government's contention that no petitioner has Article 3 standing, given the EPA's stated intention not to enforce the Clean Power Plan and instead to engage in new rulemaking. In considering standing to appeal, the question is whether the appellant has experienced an injury fairly traceable to the injury below. If so, and a favorable ruling from the appellate court would redress that injury, the appellant has a cognizable Article 3 state. Here, the judgment below vacated the ACE rule and embedded a repeal of the Clean Power Plan, and accordingly purports path the Clean Power Plan into a legal fact. There's little question that petitioner states are injured, since the rule requires them to more stringently regulate power plant emissions within their borders. The government counters the EPA's current posture has mooted the prior dispute. The distinction between mootness and standing matters, however, because the government bears the burden to establish that a once live case has become moot. The government's argument in this case boils down to its representation. The EPA does not intend to enforce the Clean Power Plan prior to promulgation of the rule, but voluntary cessation does not moot a case. This is correct under the law. Yeah, voluntary cessation does not moot because you could just start again. Yeah, this is in keeping with the law. Unless it's absolutely clear the allegedly wrongful behavior could not reasonably be expected to reoccur. Here, the government nowhere suggests that litigation resolved in its favor will not reimpose emissions limits. So it's still live because you could bring it back at any time. Voluntary cessation is not enough to moot the case. Congress did not grant the EPA in Section 111 of the Clean Air Act the authority to devise emission caps based on generation shifting approach the agency took on the Clean Power Plan. In devising emission limits for the power plants, the EPA determined the BSER that, taking into account cost, health, and other factors, it finds it adequately as demonstrated, and then quantifies the degree of emissions limitations achievable if that best system were applied in the covered source. The issue here is whether the restructuring of the nation's overall mix of electricity generation to transition from 38% to 27% of coal by 2030 can be a BSER within the meaning of the law. Precedent teaches us that there are extraordinary cases in which the history and breadth of the authority that the agency has asserted and the economic and political significance of the assertion provide a reason to hesitate before concluding Congress meant to confer such authority. Under this body of law known as the Major Questions Doctrine, both the separation of power principles and practical understanding of legislative intent, the agency must point to clear congressional authorization for a claim. This is a major questions claim. So it looks like I'm going to be disappointed. Chevron continues to live. It's just that, that there's a limit somewhere. We have found limits, which is not unknown to Chevron. Chevron already does have limits. Not many, but some. But yes, we found a new limit for Chevron. the major questions doctrine. Unfortunately, the major questions doctrine, at least up to this point, is very rarely invoked. The major questions doctrine, by the way, is the idea that the Congress does not hide mountain within molehills. It's the idea that the Congress, when they're going to delegate authority, is going to do it clearly. We saw this, for example, in the CDC mandates, for example, relating to the whole rent moratorium. First of all, it didn't make any sense under the text of the statute. But even if it did make sense under the text of the text of the statute wasn't clear enough, right? Even if somehow you could squeeze a rent moratorium into the language that the CDC was using, which no, you can't. But even if you could, you wouldn't do it anyway because of this major question doctrine. The idea is that if Congress is going to give the CDC the power to impose rent moratoriums, they're not going to do it by, the and other stuff language. They're going to do it more explicitly. And if we're going to give the EPA this kind of broad, reaching authority over something they don't traditionally have authority over, we're not going to do it in an obscure, sort of pass-by language. We're going to do it clearly, unambiguously, devoting it to the agency. We're not going to kind of sneak our way in through the tippy toes of the field. It's either there or not. So first of all, it's just not there at all. Second of all, even if it was, we'd still ignore it anyway because we don't think Congress works that way. So that's the major question doctrine. So it looks like we're doing the same thing here, right? Same kind of idea here. So two questions we can do under the statute, under the relevant Clean Air Act. Two things we can do. First of all, is it within the kind of language that's there in the first place at all, right? And then once we kind of do that analysis, we move on to step two. Hey, even if it's kind of there, is it really there? Because maybe this is the kind of thing that's so big, so major, that we don't think Congress is just going to sneak it through. Congress can't sneak it through. Basically, Congress can't do that. If you want to delegate authority, you have to do it explicitly. So we're going to say, even if somehow, some way we can sneak it through the language, no. Congress has to act more explicitly. So this maybe, it looks like it's breathing slightly new life into the major questions doctrine, which, already existed, rarely applied, maybe slightly more to be applied in the future, maybe. But if all we're doing is breathing a little bit of additional life into the major questions doctrine, you're not going to see the happiest version of the uncivil law you could have hoped for. I mean, it's not nothing, but it's not what I wanted. Okay, this is a major questions doctrine. The EPA claimed to discover the unheralded power to representing a transformative expansion of regulatory authority in vague language of a long extant, but rarely used statute designed as a gap filler. This is the kind of analysis you'd expect for a major question doctrine. Long extant, rarely used, vague, not clear, gap filler, the and other stuff kind of language. And other stuff can't do all these things. Discovery allowed it to adopt a regulatory program that Congress had conspicuously declined to enact. Given these circumstances, there's every reason to hesitate before concluding Congress meant to confer to the EPA the authority. Prior to 2015, the EPA had always sent Section 101 emission limits based on application measures that would reduce pollution by causing the regulated sources to operate more cleanly, never looking at a system that would reduce pollution. Okay, fine. So we're going to go into their prior interpretations. I don't really care that much. The government attempts to downplay matters, noting the agency must limit the magnitude of generation shifted demands to a level that will not exorbitantly costly or threaten the reliability of the grid. This argument does not limit the breadth of the EPA's claimed authority so much as reveal it. On the relevant view, Congress implicitly tasked it, and it alone, with balancing these considerations. There's a little reason I think they did so, blah, blah, blah. Given precedent counsel's skepticism towards the EPA claim that Section 111 empowers it to devise carbon capture emissions based on generation shifting, the government must point to a clear authorization, blah, blah, blah. They have no occasion to decide whether the statutory phrase system of emissions reduction refers exclusively to measures, blah, blah, blah. So, yeah, no. You don't get to see the happiest version of the uncivil you were hoping for. Chevron continues to exist. We are continuing to find limits at the outer edges of Chevron. But, it's the outer edges of Chevron. I'm disappointed. I'm sad. They are still apparently And okay, so we have one more opinion today. Biden versus Texas. Let's see if this goes anywhere. All right. All right. Biden versus Texas. In January of 2019, the Department of Homeland Security began to implement the Migrant Protection Protocols. Under MPP, certain non-Mexican nationals arriving by land from Mexico were returned to Mexico to await results of the removal proceedings under the law. The MPP was implemented pursuant to provision of the Immigration Nationalization Act that applies to aliens arriving on land from foreign territory contiguous to the United States and provides the Secretary of Homeland Security may return the alien to that territory pending proceeding under the law. Following a change in presidential administration, the Biden administration announced it would suspend the program, and on June the 1st of 2021, the Secretary of Homeland Security issued a memorandum officially terminating it. The states of Texas and Missouri brought suit in the Northern District of Texas against the Secretary and others, asserting the June 1st memorandum violated the INI and Administrative Procedures Act. Yeah, good luck. The district court entered judgment for the respondents. The court first concluded that terminating the MPP would violate the Immigration Nationalization Act, reasoning the section of the law provides the government two options with respect to illegal immigrants: mandatory detention or contiguous territory return. Because the government was unable to meet its mandatory detention obligations due to resource constraints, the court reasoned terminating the MPP would necessarily lead to systemic violation of the law, as illegal entrants were released into the United States. Second, the district court concluded that June 1st memorandum was arbitrary and capricious in violation of violation. Almost certainly not. As much as I might like it to be. No. The district court vacated the memorandum and remanded to the Department of Homeland Security. It also imposed a nationwide injunction ordering the government to enforce and implement the MPP in good faith until such time as it has been lawfully rescinded in compliance with the APA, and until such time as the federal government has sufficiently detention capacity to detain all aliens subject to mandatory detention under the law without releasing any aliens because of lack of detention. While the government appeal was pending, the Secretary released the October memorandum, which again announced termination of MPP and explained anew its reasons for doing so. The government then moved to vacate its injunction on the ground. The October 29th memorandum had superseded the June 1st memorandum, but the Court of Appeals denied the motion and instead affirmed. With respect to the INA question, the Court of Appeals agreed with the District Court that terminating the program would violate the Immigration Nationalization Act, concluding the return policy was mandatory so long as illegal entrants were being released into the United States. The Court of Appeals held the October 29th memorandum does not constitute a new and separate review. Held, the government's rescission of the MPP does not violate the law, and the October memorandum constitutes final agency action. This sounds correct under the current relevant law. Let's read more. Beginning with jurisdiction, the injunction that the district court entered the case violated the law, but the law does not deprive this court of jurisdiction to reach the merits of an appeal, even where a lower court enters a form of relief barred by that provision. The relevant law withdraws a district court's jurisdiction or authority to grant forms of relief. It does not deprive lower courts of all subject matter jurisdiction. The text of the provision makes that clear. The relevant law deprives the court of power to issue a specific category of remedies, those that enjoin or restrain operation of the relevant sections of the law. And Congress included that language in a provision titled Limitations on Injunction Relief that makes clear the narrowness of scope. Moreover, the provision contains a parenthetical that expressly preserves this court's power to issue the injunctive relief. If the law deprived lower courts of subject matter jurisdiction to adjudicate any non-individual claims, no such claims could ever arise at this court rendering the specific carve-out of the Supreme Court nugatory. So the Supreme Court has power, the lower courts don't. Fine. Statutory structures likewise confirm this conclusion. Elsewhere in the law, when Congress intended to deny subject matter jurisdiction over a particular class of claims, it does so unambiguously. Finally, this court previously encountered a virtually identical situation in a different case and proceeded to reach the merits of the suit, notwithstanding the district court's apparent violation. Turning to the merits of the thing, the relevant law provides, in the case of an alien who's arriving on land from a foreign territory contiguous to the United States, which is kind of necessary if you're arriving on land, to be quite honest, but whatever, the secretary may return the alien to that territory pending a proceeding under the law. It plainly confers discretionary authority to return aliens to Mexico. The court has repeatedly observed the way may clearly constitutes discretion. Yeah. Respondent and the Court of Appeals concede the point, but urged an inference from the statutory structure. Good luck. Because section makes detention mandatory, they argued the otherwise discretionary return authority becomes mandatory when the secretary violates the mandate. The problem is the statute doesn't say anything like that. The statute says may. If Congress had intended the section to operate as a mandatory cure of any noncompliance with the government's detention obligations, it would have not conferred that intention through the unspoken inference in conflict with the ambiguous express term may. This sounds all correct. Right? It's like, okay. No, we don't really work this way. We try to avoid conflicts in law where we can. So this is just conflicts avoidance, which is perfectly reasonable from the courts, right? Congress writes statutes. We assume that Congress is a smart Congress. I know, suspension of disbelief, but bear with me. We assume Congress is a smart Congress, and we assume that they mean things what they mean, and we assume that it must mean something. And we're going to figure out what it is. It must be weird. We're the stupid ones. It must be we're the ones who just don't get it. So we're going to assume that Congress is a smart Congress, and we're the ones that have trouble getting it. Okay. So going into that presumption, we note here that there's this mandatory authority, and then we note here there's some discretionary authority, and we note that those two things must mean those respective things. And so, yeah, this makes total logical sense. May means may. It always meant may. They don't have to do the may. And it can't possibly be this becomes mandatory if this other thing isn't true, right? Because it says may. And just read the words on the page. What does it say? Just read the words on the page. It says section A, you have to do this. Section B, you may do this. Oh, section B, you have to do this. If this. No, it just says may. This is just straight statutory construction. Nothing fancy, nothing up your sleeves. Right? This is avoidance of any sort of conflict, right? To try to do this, you're trying to read in a conflict. You're trying to force a conflict. The courts don't really like to do that. They're going to try to avoid it. They avoid conflicts within statutes. They avoid conflicts between statutes. They certainly try to avoid conflicts with the Constitution wherever possible. Like if we can read a statute in any way that is going to avoid the conflict, we'll do that. We avoid reading implicit repeals in a statute, right? This statute comes later than this statute. This statute contradicts that other statute. Oh, they must have meant to repeal the first statute. No, Congress is a smart Congress. If they had meant to repeal, they would have said it. So it must not be a repeal. It must be we who don't get it. So we're going to avoid trying to read it that way. These are all principles of judicial restraint. These make perfect logical sense from provisions of judicial restraint. The judiciary is to be restrained. This is what judicial restraint looks like, by the way, guys, because a lot of conservatives talk about judicial restraint and the value of judicial restraint. This is what judicial restraint looks like, right? Oh, it's the legislature who gets the authority. Oh, it's the legislature who's the smart legislature. It must be us. Oh, we're not going to act unless we have to. We're not going to act because it must be us who's dumb. Right? It's the legislature who's the smart ones. We're going to defer to them. This is what judicial restraint looks like. So, makes total logical sense. They're supposed to decide conflicts, not avoid them. Not if you believe in judicial restraint. 74 deeds. That's exactly wrong. They're supposed to decide conflicts, not avoid them. That's exactly wrong. Not if you believe in the principle of judicial restraint from first principles, right? Judicial restraint is a first principle, right? It is an underlying ethos. What is the role of the court? It's a first principle. It's a principle, like all first principles, that exist in the abstract. Before you ever pick up a case, you have to have principles. Like how are you to decide cases? How are you to decide cases? What are your rules for deciding cases, right? You have to decide what the rules of the game are before you start playing the game. So judicial restraint is a first principle. It exists outside of any case. It has to. It is your rule for deciding cases, right? And so it's one of your rules. So what are your rules? How are you going to go about this? So there are rules like originalism. Oh, we're going to interpret this based on its original meaning, or its original understanding, or its original purpose, or textualism. Oh, we're going to understand this based on its pure original text, right? A more textualist approach. Oh, we're going to do this based on judicial restraint. We're going to assume the legislature is a smart legislature. We're going to avoid conflicts where possible because the judiciary is to be restrained. It's the political branches that are supposed to have power, not the judicial branch. We're not supposed to have power, right? So these are all first principle considerations. You can disagree with these first principle considerations if you want to. My only note of caution here, as always, is you either have first principles or you don't. You can't pick and choose to apply them when it's convenient or not. You either believe in these things or you don't, right? You either believe in originalism or you don't. You either believe in textualism or you don't. You either believe in judicial restraint or you don't. And whether you do or not, you have to apply those all the way through consistently, regardless of the result that might emerge. I'm a proceduralist. I believe in procedure. I don't look to consequences. I'm not a consequentialist. I'm a proceduralist, right? I'm going to apply the rules through and through consistently, no matter what happens, because that's, in my view, the only way to have principles, right? If the result is not what I like, well, okay, then maybe I made a mistake in my principles. But if I'm going to change my principles, I'm going to change them all the way through. Because my principles could be wrong. I'm open to that possibility. I'm open to the possibility of attacking my underlying principles. I'm open to the possibility that principles like originalism or textualism or judicial restraint could be wrong. I am open to these possibilities. And I'm open to the possibility of revisiting these considerations. But if I change those principles, you better believe I'm going to apply them all the way through consistently. So I have to change them universally. It's the categorical imperative. I told you guys I like Immanuel Kant, right? It's the categorical imperative, right? The only principled position is a position that can be applied all the way through without contradiction. The only moral positions are those positions that can be applied universally, consistently, absolutely without contradiction. It's the categorical imperative. I believe in originalism. I believe in textualism. I believe in judicial restraint as categorical imperatives. They're absolute, without contradiction. And if we're going to change that, we're going to change it consistently. So yes, we are trying to avoid the conflict that is what we're supposed to do, in my view. And if you disagree with that view, all I'm saying is think it all the way through. Think it all the way through. You have to remember, all right? Be careful what you wish for. You might just get it. All right? What happened to speedrunning? It's the last day of the Supreme Court term. It's fine. We're having a very loose definition of speedrun today. That's what happened to speedrunning. This is a very loose definition of speedrunning. Let's see. You can't come to a decision without conflict. In no cases, all the people are happy all the time. Perhaps you misunderstand the nature of what it means to have conflict. Perhaps you misunderstand. Like I can come to a decision without conflict in my own head. That's all I'm trying to do is come to a conflict. I'm trying to come to a decision without internal conflict, not external conflict. Yeah, perhaps you misunderstand the nature of what I mean to have conflict. I'm trying to avoid it. I'm trying to avoid internal conflict. I'm trying to create a set of rules that I can apply without contradiction to themselves. I'm trying to avoid internal conflict. I'm trying to avoid, creating a system that is in tension with itself, so can I apply it consistently. There will be external conflict. People won't like it, but that's okay. But that's the nature of playing a game, right? Yeah, maybe you misunderstand the nature of what it means for me to talk about conflict. It's like playing any game you like, right? Pick any game you like off the shelf. The conflicts I'm looking for are conflicts internally within the rule set, right? The conflicts that start to exist once you play the game because people are in competition, right? Those are not the kinds of conflicts I'm interested in. I'm interested in the conflicts internally in the rules of the game. Can I apply the rules of the game consistently? Yeah, once you start actually playing the game, people are going to be in conflict with each other because everyone wants to win the game and not everyone can win. But yeah, I'm just trying to avoid the internal conflicts. So it's like, yeah, okay. So the conflict I'm trying to avoid is not the conflict in how people will perceive the decision. I'm not trying to avoid the conflict in people's happiness with the result. The conflict I'm trying to avoid is in the rules of the game. So the conflicts I'm trying to avoid are the conflicts that might appear to be existent between statutes, or within statutes, or between statutes, or between the Constitution and statutes, right? These are the conflicts I'm wanting to avoid. I'm trying to avoid reading the rules of the game in a way that the rules of the game contradict themselves, right? Oh, I've read this rule in this. I'm reading the rules of the game. I'm reading the rules of the game, and I have two different rules, and the rules of the game appear to conflict with each other. This is the conflict I'm trying to avoid. I'm trying to read both sets of rules at the same time in a way that avoids the conflict. Is there a way for me to do that so I can apply both rules at the same time? This is the conflict I'm trying to avoid. This I can do. And if I can't do it, well, then I have rules for that too, right? I have rules for that too. If I can't avoid the conflict between the rules, I have rules for that too. They're just to be avoided. In the event that the conflict is required, I have rules for that too. Those rules are such things as Constitution beats statute, statute beats regulation, right? A later enacted statute, a more specific statute beats a more general statute. A later enacted statute beats an earlier statute, right? These are the rules that apply once I have conflicts. I have rules for conflicts. Once I have the conflicts, I just try to avoid them in the first place. I have rules. I've got rules inside. I've got rules for your rules. I've got rules inside of rules. I got rules for days. All right. The historic context was adopted confirms the plain import of the text. The law was added to the statute more than 90 years after the shall be detained language that applies. And the provision was enacted in response to the BIA decision that questioned the legality of the contiguous territory return practice. Moreover, since its enactment, every presidential administration has interpreted the law as purely discretionary, notwithstanding the consistent shortfall of funds to comply. The foreign affairs consequence of mandating the exercise of contiguous territory return likewise confirms the Court of Appeals erred. Interpreting the law as a mandate imposes a significant burden upon the executive's ability to conduct diplomatic relations with Mexico, once Congress did not likely intend. And finally, the availability of parole as an alternative means of processing applicants additionally makes clear the Court of Appeals erred in holding the I require the government to continue implementing. Yeah, blah, 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 blah. This is all like perfectly logical. Roberts indicates in which Breyer, Sotomayor, Kagan, Kavanaugh join. Gorsuch apparently joins in dissent. I'd be interested reading his rationale because, of course, I'm a Justice Gorsuch fanboy. but at least on first principles, this sounds roughly correct. So, all that good stuff. All that good stuff. So, I hope you've been enjoying these discussions. I've been enjoying it. I've been enjoying it. Just checking to see what's going on in the chat here. I think I acknowledged all the super chats. 16-bit Dungeon, thanks for covering these. Brendan SCOTUS blog, thank you. Stubble said, hey, Kurt, hope you're good from sunny Scotland, which, we disputed the sunniness thereof, but then again. Drew said, hey, Kurt, thanks for covering this. Sending you best wishes from Scotland. Thank you very much. Admiral Nelson says, you look rested, Kurt. Love these streams. You're welcome. And I think that might be the last of them. Yeah, great. Yeah, exactly. Define sunny. Sunny within certain definitions of sunny. Yeah, exactly. Exactly. All right, so let's keep going on because I'd like to keep going on. Let's take a look. Let's see. First of all, let's see. What should we run? Just taking a quick look. Oh, there's an end of term statement from Chief Justice Roberts. All right, I guess we'll read the end of term statement from Chief Justice Roberts. Exciting. Let's see if I can make this a little bigger. There we go. I'm authorized to announce the court has acted upon all cases submitted to the court for decision this term. Disposition of items considered at conference yesterday will be reflected on orders list that will be released at 10:45. The court will thereby be in recess from today until the first Monday of October, which I told you that's when they start, at which time the court term will be adjourned and the new term will begin. On behalf of justices, I'd like to thank the Supreme Court employees for their outstanding work and dedication to their important responsibilities terms. I thank members of the court bar as well as for their professionalism and cooperation. Before we rise for the summer, I have a number of individual employees to recognize. Collectively, these individuals have rendered more than 5 centuries of service. From the clerk's office, Michael Duggan retired with more than 30 years of service, and Gary Kemp retired with nearly 30 years of service. From the marshal's office, Danny Venny retired with more than 38 years of service. Ernest Hicks retired with more than 36 years of service, and Willie Clapton retired with more than 25 years of service. Chief Deputy Marshal Richard Nelson retired with more than 18 years of service and more than 48 years of federal service. From Chambers, Michelle Shelley Binko retires with more than 39 years of service. Janice Harley retires with more than 36 years of service. And Tony Deluge retires with more than 14 years of service. From the Supreme Court Police, Jeff Banansky retired with more than 31 years of service. Bernard Bishop retired more than 27 years of service. Eliad Rodriguez retired with more than 26 years of service. Arthur McCackey retired with more than 25 years of service. Jeff Cooper retired with more than 25 years of service. And Casey Hills retired with more than 20 years of service. Kurt, Rawls, Dorkin, Noski, Cohen. Constitutionalist question. I love and appreciate your coverage, even where we disagree. Rawls is interesting. I'm not sure what question you're asking me, but okay. Thank you for your super chat. We sadly note deaths among long-serving employees. Virginia Singletary passed after more than 41 years of service, and Raymond Ballou passed after more than 21 years of service. Moses Humes passed shortly after his retirement for more than 22 years of service and more than 47 years of federal service. Robert Hawkins retired as Court Director of Information Technology after more than 27 years of service. Hawkins ably led a department that provides key support to nearly every aspect of the court operations. He and his team were creative, agile, and essential in allowing us to discharge the public's work through the pandemic. Lisa Maslow, who served since 2012 as the 11th librarian, who will retire this summer after nearly 34 years of service. Maslow has guided our library to embrace digital tools and resources while safeguarding its unique collection and extending a tradition of outstanding responsiveness to justice employees in the bar. The court thanks our retiring employees for dedicated service. We wish each of you well in your retirement. Very nice. Very, very nice. That's very, very pleasant of them. All right, let's take a look at Roberts' concurring decision, I think, from Dobbs yesterday. I think that would be good. And see if it makes any sense. Just give me a second to get to the right page. Excuse me. All right, Chief Justice Roberts. Let's take a look at that. The list highlights the only safe place for employment are federal sinecures. Well, federal employment is typically thought to be fairly safe. I want to know whose justice theory you like. Gorsuch. I tend to like Gorsuch. He's my guy at the moment. All right, let's take a look at this concurring opinion, see what it has to say. We grant certiorari to decide one question: whether all pre-viability prohibitions on elective abortions are unconstitutional. That question is directly implicated here. Mississippi's Gestational Age Act generally prohibits abortion after the 15th week of pregnancy, several weeks before a fetus is regarded as viable outside the womb. In urging our review, Mississippi stated its case was an ideal vehicle to reconsider the bright line viability rule, and the judgment in its favor would not require the court to overturn Roe v. Wade. Today, the court nonetheless rules for Mississippi by doing just that. I would take a more measured course. I agree with the court that the viability line established by Roe and Casey should be discarded under a straightforward stare decisis analysis. That line never made any sense. Our abortion precedents describe the right at issue as a woman's right to choose to terminate her pregnancy. That right should therefore be extended enough to ensure a reasonable opportunity to choose, but need not extend any further. Certainly not all the way to viability. Mississippi's law allows a woman 3 months to obtain an abortion, well beyond the point at what's considered late to discover a pregnancy. I see no sound basis for questioning the adequacy of that opportunity. But that is all I would say out of adherence to simple yet fundamental principle of judicial restraint. If it is not necessary to decide more to dispose of a case, then it's necessary not to decide more. I mean, that's one way of viewing judicial restraint too. Perhaps we're not always perfect in following that command, and certainly there are cases that warrant an exception. But this is not one of them. Surely we should adhere closely to the principle of judicial restraint here, when the broader path the court chooses entails repudiating a constitutional right we've not only previously recognized, but also previously reaffirmed by applying the doctrine of stare decisis. Yeah, but you did that in a case called Casey versus Planned Parenthood, which is a fractured nightmare of a case. So I'm not sure how much that counts. The court's opinion is thoughtful and thorough, but these virtues cannot compensate for the fact that its dramatic and consequential ruling is unnecessary to decide the case before us. I mean, this sounds a lot like Roberts, to be sure, right? This is a more moderated approach. It's a cautious approach. It is a tempered approach. It is something that is like, and also from first principles, it is also a restrained approach. But as he himself points out, Judicial restraint isn't itself an inexorable command, and itself can be a vice. I think, everything taken to excess can be a vice, right? The difference, it's like, being, you can't, for example, be too timid, and you can't be too bold. To be too timid is to be too timid. To be too bold is to be reckless or brash, right? You need to have something in the middle to meet the right sort of thing. Everything taken to extremes pretty much runs into problems. So, is this such a case? Well, I mean, he has a point. The only sort of counter to all that is that Roe itself is a bit of a garbage opinion. From first principles, it's completely garbage. So I suppose you could get rid of Roe and try to do it again from first principles, but then again, where are you pulling this from is a bit of a problem. So that's like Robert's problem. So Robert says, okay, let's get rid of Casey, which, fair enough, because Casey is a muddled mess. So I think, I would have not expected them to get rid of Roe. I didn't think they'd go all the way. I thought they'd get rid of Casey because Casey is, is a problem. But Robert's approach here is sort of a middle ground approach. It's like, well, let's try to find something more moderate that that will satisfy what Mississippi was trying to do and not answer more than we had to, right? Mississippi wants to know, is our 15-week ban legal? All we had to do is say yes. We didn't have to say more. So, I mean, there's a point there to be had. Let me begin with my agreement with the court on the only question we need to decide here, whether to retain the rule from Roe and Casey that a woman's right to terminate her pregnancy extends up to the point the fetus is regarded as viable. I agree this rule should be discarded. First, this court seriously erred in Roe by adopting viability as the earliest point in which a state may legislate to advance its substantial interest. Roe sets forth a rigid three-part framework anchored to viability, which more closely resembles a regulatory code than a body constitutional law. Preach. That framework, moreover, came out of thin air. Also preach. Neither the Texas statute challenged in Roe nor the Georgia statute at issue in its companion case, Doe versus Bolton, included any age limit. No party or amici asked us to adopt this rule. And as for Casey, arguments for or against viability played only de minimis role in briefing oral argument. Yeah, so the rule that they applied came from absolutely nowhere. The Supreme Court just invented it out of whole cloth, which is probably why they should avoid doing that. It is thus hardly surprising that neither Roe nor Casey made a persuasive or even colorable argument for why the times must extend to viability. The court's jurisprudence on this issue is a textbook illustration of the peril of deciding a question neither presented nor briefed. Yeah, and then he's going to apply that same principle here. The only sort of counter to Roberts here that Roberts somewhat ignores is that while in some sense it might not be briefed exactly within the confines of this case, it's been briefed, as it were, for the last 50 years. These issues have been well studied and well discussed. So unlike Roe, where there was no Roe before Roe, so Roe is the first case. Roe is deciding more than it needs to, and it's deciding more than it needs to from nowhere in particular, right? It isn't in it isn't in the text of the statutes. It isn't in the text of the Texas statute. It isn't in the text of the Georgia statute. It's not in any of the amici briefs. It's not in the parties' briefs, right? This thing is just coming out of nowhere with no briefing, no foundation. The Supreme Court's just inventing it from nothing. So here he's like, well, this is a bad principle. Okay, it's a bad principle. It doesn't quite flow, but that's the same problem here, because obviously Roe exists now, and it's existed for quite a while, and there's been quite a lot of thought on the subject. So it's not quite the same problem that they had when they were enacting Roe, or deciding Roe, I should say. 20 years later, the best defense of the viability line from Casey's plurality could conjure up was workability. And although the plurality attempted to add more content by opining, it might be said that a woman who fails to act before viability has consented to the state's intervention on behalf of the developing child. That mere suggestion provides no basis for choosing viability as the critical tipping point. Yeah. A similarly implied consent argument can be made with respect to the law banning abortions after 15 weeks, well beyond the point at which nearly all women are aware they're pregnant. The court's jurisprudence since Casey, moreover, has eroded the underpinnings of the viability line, such as they were. The viability line is a relic of a time when we recognize only two state interests warranting regulation of abortion: maternal health and the protection of potential life. This changed with Gonzalez versus Carhart. There we recognize a broader array of interests, such as drawing a bright line that clearly distinguishes abortion and infanticide, maintaining social ethics, societal ethics, and preserving the integrity of the medical profession. The viability line has nothing to do with advancing such permissible goals. Consider, for example, statutes passed in a number of jurisdictions that forbid abortion after 20 weeks of pregnancy, premised on the theory the fetus can feel pain at that stage of development. Assuming that the prevention of fetal pain is a legitimate state interest after Gonzalez, there seems to be no reason why viability would be relevant to the mere permissibility of such laws. The same is true of laws designed to protect the integrity and ethics of the medical profession and restrict procedures likely to coarsen society to the dignity of human life. Mississippi's law, for instance, was premised in part on the legislature's finding that dilation and extraction procedure is a barbaric practice dangerous for the maternal patient and demeaning to the medical profession. That procedure accounts for most abortions performed after the first trimester, 2 weeks before the period at issue in this case, and involves the use of surgical instruments to crush and tear the unborn child apart. Again, it would make little sense to focus on viability when evaluating a law based on these permissible goals. Robert's analysis makes a lot of sense here. In short, the viability rule is created outside the ordinary course of litigation, is and always has been completely unreasoned, and fails to take into account the state interest since recognized as legitimate. It's indeed telling that other countries almost uniformly eschew viability. Only a handful of countries, among them China and North Korea, permit elective abortions after 20 weeks. The rest have coalesced around 12 weeks lines. So the United States, and this is true, and one of the things that the pro-choice side seems to blatantly ignore, the United States has been well on the excess of international law on this issue. No countries allow abortions as late as the United States does. And it feels like, well, we should be more like Europe. Europe, this rule from Mississippi is much closer to a European rule than not. So, yeah. The motion to dismiss was denied? That's bullshit. That's bullshit. None of this, however, requires that we also take the dramatic step of altogether eliminating the abortion right first recognized in Roe. Mississippi itself previously argued as much to this court in its litigation. When the state petitioned for our review, its basic request was straightforward: clarify whether abortion prohibitions before viability are always unconstitutional. The state made a number of strong arguments. The answer is no. Arguments that, as discussed, I find persuasive, and went out of its way to make clear it was not asking the court to repudiate the attorney's statements as objectively outrageous. That's a bad decision. That's a bad decision. The statement is objectively outrageous? No. 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 That's a bad decision. That is a bad decision. So this lawsuit, I guess, will continue. And I suppose that means discovery. Now we have to have discovery fights about it, right? Because now we can get to discovery. So now we have discovery fights, and now they're going to ask questions in discovery about what they knew and when they knew it and all the rest of it. And the laundries will plead the fifth to all of it, and adverse inferences and all the rest of it, and huge dollar damages and an appeal. Man, what a nightmare. What a bad decision. This is the kind of thing that leads to the sentiment: the tough cases make bad law. This is exactly where that kind of idea comes. This is, in some people's view, this is a tough case. I tend to think that the laundries made the morally correct decision in defending their kin. This is a somewhat unpopular view, But this view is informed by a couple things. First of all, on a purely objective level, how many times have I told you guys to keep your mouth shut? How many times have I told you guys that, keep your mouth shut and ask for a lawyer, right? So they kept their mouth shut and asked for a lawyer. And they advised advised the kid to keep his mouth shut and ask for a lawyer. So how can that be morally wrong? How can I sit here on the one hand and tell you guys repeatedly, over and over again, as I have so many times, how can I sit here and say, get a lawyer, invoke your right to remain silent, remember the mantra, I want to remain silent, I want a lawyer? How many times have I told you this? And then I'm going to turn around and say, oh, they're morally wrong for doing that? That's some bullshit, right? So I think they're morally correct. They gave the same advice to themselves that I would give them. Keep your mouth shut. Don't talk to them. How's that morally wrong? It doesn't make any sense, right? It doesn't make. I don't buy it, right? So they kept their mouth shut. So that's correct. It's morally correct. It's legally correct. Unless you're going to try to say that the right to remain silent is morally wrong. Unless you want to say the right to keep silent is morally wrong, and you just want to attack the Fifth Amendment as being morally wrong, which, okay, more power to you, I guess. They're trying to say if you speak, you must be guilty. That's wrong. Everyone has a right to remain silent. This is just made up. Yeah. Maybe it's time to put another's interest in front of their own, like their own Fifth Amendment right, their right to their own kid. It's time to put another person's interest in front of their own. Really? So you don't believe in the right to remain silent. You don't believe the right to remain silent exists if it's important enough or if it's devastating enough. You don't believe in your right to your own. You don't believe that they should have a right to remain silent that's absolute. You think that their interests should succumb to someone else's interests at some point. So you don't really believe in I want a lawyer, I want to remain silent. You don't believe that you don't believe in that principle through and through. You don't believe in it in a moral sense. Then it must be a morally incorrect rule. I mean, I told you I'm a fan of Immanuel Kant. I'm a fan of the categorical imperative. Immanuel Kant says that the only ethical rules are those that can be maximized without contradiction. You're telling me that there's a contradiction. So now it's no longer an ethical rule from first principles. If it can't be applied absolutely it's not an ethical rule. So now the Fifth Amendment is no longer an ethical rule. So we should repeal the right to remain silent because it's not an ethical rule. I don't follow this. Acting in your own best interest can be immoral. Then it's immoral to act in your best interest. That's the logical conclusion. If acting in your own interest can be immoral, then it's immoral to act in your own interests. This is a strange proposition to me. You guys are trying to argue for me that invoking your right to remain silent can be immoral? Really? So you're telling me that as a lawyer, I'm constantly giving out immoral advice? I know the law and morality aren't the same, but you're telling me that I'm giving out immoral advice now, right? Because my advice is, as always, to be silent, to remember the mantra. I want a lawyer. I want to remain silent. My advice is absolute. You don't even know what your points of vulnerability are. You don't even know what your exposure is. You can't even guess what your points of exposure are. Neither can your lawyer, incidentally, because they don't know what the police know or what the police think they know. You have no clue what your exposure is. You have no idea what it might look like now in the future, right? So my advice is absolute. Get a lawyer. remain silent. Invoke your rights. I want a lawyer. I want to remain silent. So you're telling me that I'm giving out immoral advice? I'm counseling people to do things that are immoral now, so I'm an immoral person? Okay. I didn't know I was an immoral person. This is a strange proposition to me. Okay. Well, apparently I'm an immoral person. All right. Well, fair enough. I need to give advice on the best interest of my client, but apparently that's immoral. So you can't have it. I want a rule set. Let me explain this again, because apparently some people in the back got lost along the way. I'm a proceduralist. I'm a proceduralist, not a consequentialist. I look to procedure. I look to rules. I like rules. I want to follow rules. I think following rules is the only way to be consistent. If you look at consequences, then you're no longer principled. I want to be principled. I think it's good to be principled. My principle is it's good to be principled. I think the only way to do that is by looking at principles, not consequences. If you're looking at consequences, you're no longer looking at principles. I want to be principled. I want to be a principled person. If I'm looking at consequences, I'm not a principled person. Now I'm looking at consequences. Now I'm making decisions based on the results, not on the principles. The only way to be principled is to be principled. So I want to look at the principles. I want to apply the principles. My view is that the principles have to be applied absolutely. I want the principles to apply in every possible situation without contradiction. The rules to every game you've ever played are rules that exist without contradiction. They are rules that are maybe nuanced or complex, but play any board game and open the rules. Open Monopoly or, Risk or Axis and Allies or, any board game in the history of time. The rules exist without contradiction. The rules are absolute. The rules exist a priori of the game. The rules exist before the playing of the game. If you're looking to consequences of what happens in the game, you're no longer applying the rules. You have to apply the rules. The rules are only correct if they apply without contradiction. The rules are only correct if they can be applied absolutely. The rules are only correct if they can be maximized without contradiction. Otherwise, the rules are wrong. Okay. I believe one of the rules is a right to remain silent. I believe one of the rules is your right to an attorney. I believe this absolutely. I believe that there is an absolute, unquestioned right to remain silent. I believe that this rule exists absolutely. This is the rule of the game. If you do not use this rule of the game, bad things will occur to you personally. It is therefore my advice that you invoke this rule. All right. This is my premise. Now we have the chat suggesting that this rule can be immoral as applied in some circumstances. If the rule is immoral as applied in some circumstances, the rule itself needs to be changed. Because the only ethical rules are those that can be applied absolutely. This is my conceit. This is a premise. This is a baseline a priori premise. This is a root premise of mine. The only rules that can be applied are those that can be applied without contradiction. If there's contradictions, the rule sucks and needs to be changed. So you guys are telling me the rule as applied in some circumstances is immoral. Well, I don't want to be immoral. I want to be moral. I want to be moral. I want to be a moral person. I don't want to be immoral. That's no good. I want to be moral. So now you're telling me my rule is immoral. So now I can't give the rule. So now I'm like, what is the rule? What is the rule? Please tell me. What is the rule? I don't want to be immoral. If you're telling me my rule as applied is immoral, you're telling me I'm immoral. Because I think the only moral principles are those that can be applied absolutely. So I'm immoral. Because I have a rule that can't be applied morally, consistently, absolutely. That makes me immoral. I don't want to be immoral. I want to be moral. It must be the rules wrong. How do I fix the rules so it's better? How do I fix it? And I want to be moral. Please tell me how to be moral. Please tell me, and I'll lobby for change. I'll lobby for change. We need a constitutional amendment, man. We need a constitutional amendment. The Constitution is immoral. I don't want it to be moral. That's no good. I don't like immoral. I mean, the Constitution's been immoral before. The Constitution used to recognize slavery. That was immoral. We had a constitutional amendment to fix the morality. The Constitution can be immoral. It has been immoral. Maybe it's still immoral. Maybe the Fifth Amendment is immoral. We need a constitutional amendment. We can't have the Fifth Amendment anymore. It's immoral. How do I fix it? How do I fix it so it's moral? Please tell me. How do I give moral advice that's morally right? How do I do that? Please tell me. How do I change the rule? How do I change it so I fix it? I have to have a rule that applies consistently. I have to have a rule that's absolute. I have to have a rule that can be applied without contradiction. The rule can be complex, it can be nuanced, it can be multifaceted, but it has to be absolute. I don't want to be immoral. How do I become a moral person? Please let me know. Can we cover the ruling? I'll tell you what, Luke. We can discuss what I want to discuss when I want to discuss it. How about that? How about that for a rule? After we grant certiorari, however, Mississippi changed its course. In its principal brief, the state bluntly announced the court should overrule Roe and Casey. The Constitution does not protect the right to abortion, it argued, and the state should be able to prohibit elective abortion if it rationally supports doing so. The court now rewards the gamut, noting 3 times the parties presented no halfway measures, and argued we must reaffirm or overrule Roe and Casey. Given these 2 options, I don't have to invoke it. I suppose I should. I suppose I don't have to. I suppose I don't have to. But one of my roles as lawyer is as counselor. Right? I can give people advice to not do things that are legal if I think there's another reason for them not to. I mean, I certainly have to tell them what the law is, but I don't have to stop there. The rules of ethics are quite clear on this. Right? So just because you can do a thing legally, and you come to me and say, can I do this thing legally? The law perfectly allows for me to say yes, but I don't think you should. I don't think that's a good thing for you to do. Here's some other considerations. Those considerations can also be self-interested from your point of view, right? Yes, it would be legal for you to do it, but it's not a good idea because it would result in these collateral consequences, which are negative to you in these following ways, right? This is a bad idea for you. So I can even give it from purely selfish reasons for them. Or I can be like, yeah, it's okay for you, but it leads to these collateral consequences for society. You shouldn't do it. All right. So when should I tell my client, yes, you have a Fifth Amendment right to remain silent, but you shouldn't use it? When should I do that? From a moral posture. Yeah, you have a right to remain silent, but you shouldn't. You should talk to the police and you should tell them what you know. You should do that. When should I give this advice? Please tell me. The framing is not accurate. In its brief on the merits, Mississippi, in fact, argued at length that a decision simply rejecting a viability rule would result in judgment in its favor. But even if the state had not argued as much, it would not matter. There's no rule the parties can confer this court to disposing of their case on particular ground, let alone when review was sought and granted on a different one. Can someone be charged for not assisting the police in the United States? No. As a matter of fact, they can't. The police are constantly confused by this. I assure you, they are very, very confused on this. But the answer is no. There's no, well, okay. Unless, they are deputizing you as a posse, which I don't know when the last time that happened was. So, short of that. But okay, let's just go with the general no and leave it at that. Yeah. If the police come to you and say, we want you to cooperate, you don't have to. You can't interfere with them. You can't mislead them. So you can't give them wrong information. You can't give them false information. You can't physically restrain them. You can't stop them, but you don't have to help them. That is not obstruction. That is not obstruction. It's like, you're an eyewitness. Yes, I am. Tell us what you know. No. Okay. No. Now, the prosecutor may want to force you to cooperate, and there's ways to do that through a subpoena, for example, to a grand jury. Then you'd have to cooperate because you have a court order. But also, incidentally, when that happens, you're given immunity by virtue of you being at the grand jury, because you're being compelled to testify against yourself, or compelled to testify, period. So the only way that can happen is with immunity, which is exactly why you should wait for it, right? It's like, yeah, I'm not going to talk to the police. The prosecutor's like, oh, you won't talk to the police? I'll get a material witness warrant. It's like, you don't need a material witness warrant. If there is some lawful order, I will follow it. If you order me to show up at the grand jury and tell everything I know, I will absolutely do it. Incidentally, I'm not signing a waiver of my immunity, which is provided by law. So, you can force me to testify as a witness, but you have to do it with a grant of immunity. You can force me to testify at the trial, but only with the grant of immunity. Then yeah, okay, well, great. So that you can force it in that sense, but you can't in the first instance when the police just come and be like, yeah, you're a witness, yes, tell us what you know. No. Now the police who don't know these things will absolutely arrest you for obstruction. You'll just win. You'll just win. It's like, if you don't cooperate, we're going to arrest you, which I always thought was a stupid thing, because if you don't cooperate, we're going to arrest you. I'm like, the moment you arrest me, you have to give me a Miranda, and you're going to tell me I have a right to remain silent. So the whole thing is kind of pointless, but okay. Yeah. The framing is not accurate. In its brief on the merits, Mississippi in fact argued at length the decision simply rejecting the viability rule would result in judgment in its favor, but even if the state had not argued as much, it would not matter. There's no rule the parties can confine this court to disposing of their case on particular ground, let alone when review was sought and granted on a different one. Our established practice is instead not to formulate a rule of constitutional law broader than required to precise facts. I mean, he's got a point. He's absolutely got a point. So it totally makes sense. Yeah, this is so true. This is so true. You do not know how you could incriminate yourself. I guarantee you don't know. You don't even know where your weak spots are. You have no clue. You have no clue where your weak spots are. And you won't find out until it's way too late if you try to cooperate. I guarantee you. No, you still have to give Miranda. It's just not the basis of a 1983 suit, which was a questionable decision, but still. Here, there's a clear path to deciding this case correctly without overruling Roe, all the way down to the studs. Recognizing the viability line might be discarded, and majority rightly does, and leave for another day whether to reject any right to abortion at all. It's a moderated decision. It's a logical decision. So I'm definitely not as critical of Chief Justice Roberts here as a lot of people have been. It certainly is loyal to the way the case was framed by Mississippi. Of course, such an approach would not be available if the rationale in Roe and Casey were inextricably entangled and dependent upon viability. It is not. Our precedent in this area grounded the abortion right in a woman's right to choose. If that is the basis for Roe, Roe's viability line should be scrutinized from the same perspective, and there's nothing inherent in the right to choose that requires it to extend to viability or any other point, so long as a real choice is provided. To be sure, in reaffirming the right to abortion, Casey termed the viability rule the central holding. Other cases of ours have repeated the language, but simply declared does not make it so. The question in Roe was whether there's any right to an abortion in the Constitution. How far the right extended was a concern that was separate and subsidiary, and not surprisingly, entirely unbriefed. The court in Roe just chose to address both issues in one opinion. It first recognized the right to choose to terminate a pregnancy under the Constitution, and then, having done so, explained the line should be drawn on viability. Such a state could prescribe abortion before that period. The viability line is a separate rule of fleshing out the metes and bounds of Roe's core holding. Adopting principles of stare decisis, I would excise that additional rule and only that rule from our jurisprudence. That makes sense. The majority lists a number of cases that have stressed the importance of the viability rule to our abortion precedent. I agree that whether it was originally holding or dictum, the viability line is clearly part of our past precedent, and the court has applied to such cases since Roe. My point is that Roe adopted two different rules of constitutional law: one, that women have the right to choose to terminate pregnancy; two, that such right might be overridden by the state's legitimate interest when a fetus is viable outside the womb. The latter is obviously different from the former. I'd abandon that timing right now, but see no need in this case to consider the basic right. The court contends it's impossible to address Roe's conclusion that the Constitution protects a woman's right to abortion without also addressing Roe's rule. The state's interests are not constitutionally adequate to justify abortion until viability. But we've partially overruled precedent before, and certainly never held that a distinct holding defining the contours of a right must be treated as part and parcel of the right itself. Overruling the subsidiary rule is sufficient to resolve this conflict. The law at issue allows abortion up through 15 weeks, providing an adequate opportunity to exercise the right protected by Roe. By the time a pregnant woman has reached that point, her pregnancy is well into the second trimester. Pregnancy tests are now inexpensive and accurate, and a woman ordinarily discovers she's pregnant by 6 weeks of gestation. Almost all know by the end of the first trimester. Safe and effective abortifacients, moreover, are rarely available, particularly during early stages. Given all this, there's no surprise the vast majority of abortions happen in the first trimester. Presumably, most of the remaining would also take place earlier, if later abortions were not a legal option. Ample evidence suggests that a 15-week ban provides sufficient time, absent rare circumstances, for a woman to decide her decision. Actually, I'm a lot more supportive of this decision than the general zeitgeist has been for Chief Justice Roberts. I think what he's saying makes a lot of sense, particularly because, as he points out quite correctly, this is how the case was framed to the Supreme Court. They were framed with the decision as whether or not the 15-week ban was correct. And in their briefing, Mississippi said you didn't have to overrule Roe, then trying to change pace at the oral argument. A little bait and switch, maybe. So I think Chief Justice Roberts' answer makes a lot of sense. It's like we're not necessarily saying we only have to decide as much as we have to decide. This is a fine principle of judicial restraint. This is a fine principle of conservatism. It's not the only principle, mind you, but it's a fine principle. And so, why are my eyes? I'm having a day on allergies, apparently. But it's a fine principle. It's like, yes, the viability line doesn't make any sense. But so 15 weeks is enough. And as for the rest, come back and ask us another time. It does kick the can down the road, a little frustratingly, perhaps, but it is one of the things the Supreme Court does. So I'm less critical of Robert's opinion here than a lot of people have been as part of the general zeitgeist. So, it's basically, let's not decide more than we have to decide. And leave the rest for another day. Kicking the can down the road, perhaps very frustratingly, but it is technically what they were asked to do. So it's a very sort of technical thing. Although it does somewhat contradict to some degree what Roberts' decision looked like in the Obamacare cases, where he arguably strayed outside that principle in order to uphold Obamacare beyond what he was asked to do. So, and is not restrained in that view. So Roberts is not definitely absolute in that sense. Well, I think this is interesting, to be sure. Yeah, this is interesting for sure. Good morning to you, T in Tennessee. Good morning. All right. Well, 651 of you here. I am looking for a new thumbnail editor. I've put out some feelers on Upwork and Fiverr. I have largely been disappointed with the quality of work that I've gotten. So if you can create thumbnails for my videos with fairly minimal direction, mostly the direction being create a thumbnail for this video, and if that's of interest to you and you're willing to, it would be a paid gig. So it would depend on what rate we can negotiate that would be reasonable and fair. But if you're in the graphic designer space and, can create interesting thumbnails that are attention getting and, all the things that thumbnails need to do, if this is you, please let me know at uncivillawYT@gmail.com. I am currently in the process of vetting a thumbnail editor because my current one kind of ghosted on me for some reason, and that was annoying. So I need to hire a new one, and I suck at the thumbnails. So yeah, I need help on the thumbnails. So if that is you as a graphics designer and you'd like to, if you're comfortable with here is a video, create a thumbnail for it that's interesting and engaging and and clickbaity and does all the things that a thumbnail needs to do for the YouTubes, let me know. uncivillawYT@gmail. Would I do a debate video with Natalie on this? Absolutely, I would. Of course. In fact, we kind of discussed this a little bit yesterday about discussing originalism. If you go watch, I did a video with her yesterday. If you go watch towards the end of that video where she's like criticizing and just bashing originalism over the top of the head, you'll see me looking very, very uncomfortable. It's like, oh, you're questioning everything I believe in from first principles, man. Yes, I'd be happy to discuss it with originalism, so all that stuff. Good times. So how's my transition going from full-time lawyer to full-time YouTuber? It's all right. It's all right. Could be better. Anyways, we'll press on. So yeah, graphic designer, email. It's YT, by the way, not YY. uncivillawYT@gmail. And put thumbnail in the description if that's you, and let me know what you would charge on an hourly basis to produce these things, and we'll go from there. So yeah, I do have access to stock images from one of those services, so I have a lot of stock images that you could use to create such things, and we'd be creating them, by the way, inside of Canva. Which is a creation for thumbnail tools, which is also because it allows me to have the ability to make changes if I need to. So yeah, we'll make them inside Canva. So if that's of interest to you, let me know. Okay. Well, until later, my friends, I hope all is well. Cheers later. Cheers, my friends. And goodbye.